Good morning to everybody.
Good morning, Your Honor. Can you hear me okay?
I can, thank you.
Good morning, Judge Farley. How are you?
I'm good, thanks. How are you, Mr. Bunker?
I am doing well, thank you.
So I'm not seeing anybody here on behalf of staff. Does anybody know anything about that? Okay. Let's give it a few more minutes. Do either you, Mr. Stoffel, or you, Mr. Bunker, have contact information? I believe Mr. Valentine and his firm are representing staff in this. And number one, is that correct? And number two, do either of you have contact information for him that you can lay your hands on quickly and maybe email and or call him?
That's correct, and I'm happy to give him a call if you'd like.
That would be great. I'd appreciate it. So why don't you go ahead and do that, Mr. Stoffel, and we'll just be off the record here for a few more minutes. Why don't you just report back to me, Mr. Stoffel, when you're done?
Will do.
Thanks.
All right, I can report that we got a hold of Mr. Valentine and he is going to try to dial in. So we can give him a moment to do that. And then he said, if he's unable to connect by phone, he will take it as it is. So. And you're muted, Your Honor.
Thank you. I appreciate that. And thank you for contacting Mr. Valentine.
Hi, Judge. I'm here. Sorry for being late. I've had connectivity problems and I'm on the road, so.
Understood. That's just fine. You're here now, so that's all good. Give me just a moment. Let me just make sure that Ms. Boulay, are you ready to go?
Good morning, Judge. I'm ready.
Great. And it looks like Miss Federico is the wizard on this one. Miss Federico, are you ready to go?
It's actually Stephanie. I'm just here to observe.
Okay.
Good morning, Judge. We're ready.
Good morning. Thank you. We are on the record in the Colorado Public Utilities Commission's consolidated proceeding numbers, 22AL-0348G and 23AL-0235G. My name is Connor Farley. I am the administrative law judge assigned to this proceeding. It is approximately 10:36 a.m. on July 20th, 2023, and this remote pre-hearing conference is being webcast. This remote pre-hearing conference was scheduled in decision number R23-0428-I dated June 27th, 2023. So with that, let's have appearances starting with Atmos, please.
Thank you. Nick Stoffel with the law firm of Holland and Hart, appearing on behalf of Atmos Energy Corporation. I'd also like to enter the appearance for my partner, Thor Nelson.
Thank you very much, Mr. Stoffel, and welcome. We'll turn next to staff.
Thank you, Your Honor. Mark Valentine, Special Assistant Attorney General for trial staff.
Thank you. And finally, UCA.
Good morning, Your Honor. Senior Assistant Attorney General Gregory Bunker on behalf of the Colorado Office of the Utility Consumer Advocate.
Thank you and welcome to you all. So this should not take long. I wanted to hold this remote pre-hearing conference really for two purposes. First off has to do with the notice that was addressed in decision number R23-0428I that issued on June 27, 2023. That interim decision required Atmos to, and I'm somewhat paraphrasing here, post a customer notice in decision number C23-0320 on Atmos's website and serve both on all parties in proceeding number 22AL-0348G. Mr. Stoffel, I just want to confirm that both of those things were done.
Confirmed.
Great, thank you very much. So the second thing is I want to address the schedule. It seems like somewhat, I'll characterize it as a minor dispute between UCA and the other two parties. What I'm interested in hearing just a little bit more about, and I'm going to turn to Mr. Bunker since it sounds like UCA is the one who's made this argument. UCA, as I understand it from the conferral report that was filed by Atmos, and thank you very much for doing that, Mr. Stoffel. In that conferral report, my understanding is that UCA is contending that it has an equal burden of going forward, and I'm quoting now, on the issue regarding the calculation of short-term debt. And that was on the second page of that conferral report that was filed on July 19th, 2023. So I just want to hear a little bit more about that. And first of all, just kind of a preliminary question for you, Mr. Bunker. I mean, my understanding is what's been remanded to me are two issues. One is the calculation of short-term debt, having to do with storage of gas and the return on that. And then the second is the weighted average cost of debt on SSIR amounts starting on January 1st, 2024. So in the conferral report, as I just read, talked about this equal burden of going forward, but it only addressed one of those issues, and that was on the calculation of short-term debt. So was that in fact correct? Does UCA not contend it has an equal burden of going forward on the other issue, the weighted average cost of debt on the SSIR amounts?
No, Your Honor, that may have been an oversight on UCA's part to not be a little more specific in terms of the calculation as to both of those debt items that have been remanded back to you. And the UCA's view, frankly, is that you've got two competing arguments here in terms of calculated either under scenario A or scenario B, and that it would create a more fulsome record, for Your Honor, if there were two rounds of contemporaneous testimony filed, that being that all parties file direct testimony, all parties file answer testimony so that everyone knows what the other parties are saying and has a chance to respond. Whereas under the more, I believe Atmos characterized it, the traditional method of direct answer and rebuttal testimony, that really wouldn't be the case. In terms of Atmos would have, if you will, 2 bites at the apple. UCA and staff would have 1, and that perhaps the record would not be quite as fulsome for you. And because we do have an expedited process here in terms of a hearing scheduled for September 29th is what you've suggested as the last day for hearing, and what we've suggested as parties for that hearing, that's a pretty fast turnaround. And that by cutting out 1 round of testimony and allowing essentially all parties to have the same opportunity to put evidence into the record before you, that would be a better approach in the mind of the UCA.
Okay, so it sounds like you're just being more functional / practical than anything else, Mr. Bunker. I mean, this whole thing about, separating out the burden of going forward versus the burden of persuasion kind of confuses me. I've seen that done in other contexts, but for very specific reasons that I'm not sure apply here. So, I mean, first of all, it sounds like you're not contesting that the ultimate burden, we'll call it, burden of proof or burden of persuasion, rests with Atmos. Is that right, Mr. Bunker?
Correct.
Okay.
Suggesting that Your Honor is going to be deciding one of 2 calculation methods, and that it essentially levels the playing field for all parties to be able to put, their view in front of you and to respond to the other side's arguments.
Okay. And like I've said, I'm aware of the burden of production and burden of persuasion being separated out in other contexts, mainly, frankly, on summary judgment at the federal level in employment cases. I've also seen it done where there's a rebuttable presumption, and then what we've all learned, at least people of my vintage, in law school, was a burden of proof gets separated into 2: burden of production or going forward, and burden of persuasion, or really the ultimate burden of proof. I mean, I've seen it done in those contexts. I just haven't seen it done in this context, and it doesn't really make sense to me. So, so under your proposal, Mr. Bunker, I mean, nobody would have rebuttal. It'd just be 2 rounds of written testimony.
That is correct.
Okay. All right. Mr. Stoffel, do you want to respond?
Yes, I mean, I think from our perspective, this is pretty straightforward. Commission Rule 1500 governs when a tariff is suspended, as was the case for this proceeding. The utility has the burden of proof, and as UCA just conceded, they agree. Atmos has the ultimate burden of proof here, and for that exact reason is why we believe it's appropriate for Atmos to have the last word, or the second bite at the apple, as Mr. Bunker phrased it. And that is consistent with the traditional process in a commission proceeding where a tariff is filed and suspended for an evidentiary hearing.
Okay.
And if I could, I would like to visit with you about the second issue you raised on the SSIR. We're certainly aware that the commission remanded that back to you, but we're somewhat puzzled because that tariff was not suspended. And that tariff absolutely spells out how the cost of debt will be determined and calculated for purposes of the SSIR investments in 2024 and 2025. And so I think the parties certainly have been focused on the cost of short-term debt issue, and we know what's going on there, but we are a little confused about how the tariff that was not suspended was part of this remanded proceeding.
Well, let's remind me, Mr. Stoffel, to come back to that. But I'll preface what I'm going to tell you, which is I know what you know, which is what's in the decision, and I really don't know any more than that. So I'm not sure I'm going to be able to provide. If you're looking for understanding, I'm not sure I'm going to be able to provide any further understanding, but let's come back to that. And let me just ask Mr. Valentine. Mr. Valentine, I understand staff's position. Well, why don't I let you tell me what staff's position is on this?
Thank
the
you.
two
Thank-
competing schedules.
Yes, thank you, Your Honor. Staff generally takes Atmos view of this. It is appropriate for the utility to have the last word because this is a tariff filing and they have the burden of proof.
Okay. All right. Understood. Okay, well, why don't we come full circle now, Mr. Stoffel, and I'll just tell you again, I'll just reiterate on the issue of the calculation of the weighted average cost of debt for the SSIR. Like I said, I know what you know, which is what's in the commission's decision remanding it. I have recognized that the SSIR tariff was not suspended as well. But I really can't provide any further clarification on that. I mean, I would note, as I understand it, that SSIR tariff. Well, you help me with this. I haven't looked at it in a bit. Is it going into effect on January 1st, 2024, or what's happening with that? I know January 1st, 2024 is an important date with respect to that. So go ahead, Mr. Stoffel.
Yeah, so the SSIR tariff, both has procedures for how the SSIR works and defines what costs are included in the SSIR, and after the compliance filing also spells out the return on investments in 2024 and 2025. And so that part of the tariff, the procedure part, is in effect. That went into effect on May 13th with the compliance filing. And so the part that will change through an advice letter filing later this year, effective January 1st of next year, is the rate component, which will follow the procedures that were implemented and spelled out in the tariff that took effect earlier this year. And so there is, I guess, a burden of proof question to the extent a party is now challenging the SSIR. That's an effective rate that was put into place pursuant to the commission's decision. And so I don't think the burden's on Atmos to continue to show that that is just and reasonable in the absence of a complaint or challenge to that rate. And perhaps this is a non-issue. I don't know if UCA and staff actually intend to challenge the calculation of the debt cost on the SSIR. I think part of it may have been confusion that for the GCA issue, it was the calculation of short-term debt, which is not otherwise used to set rates. Whereas for the SSIR, it was the long-term debt, which was used to establish the WACC in the rate case and was known for us to be able to put that into the tariff and use for the SSIR filing next year.
So I heard a question posed to staff and UCA, and I'll let you, each of you respond. We can start with, Mr. Bunker, you unmuted yourself, so go for it.
Thank you, Your Honor. I have to admit, I do not recall if the tax gross up issue was part of the SSIR long-term debt calculation. I know that is part of the short-term debt calculation, but I have to admit, I do not recall the specifics of that issue.
And Your Honor, I could represent that grossing up the short-term debt cost for taxes is expressly in the tariff that went into effect on the 13th for the SSI.
And if the tax gross up, the interest costs, facility fees, if all of those issues are part of that SSIR tariff, then I think it still is in play.
And the facilities fees issue is not, because that is related to the short-term debt facilities. The issuance costs associated with long-term debt, which is the debt return on the SSIR, is already reflected in that interest rate.
Okay. Mr. Valentine, why don't you go ahead?
Thank you, Your Honor. I think that the best way to handle the scope of this is going to be through testimony. I mean, I think that the parties will address what they need to in testimony, and that will set the scope of the hearing. To the extent that there are rates already in effect, what's included in those rates, I don't think is properly before you right now.
Okay. So, Mr. Stoffel, could you tell me again, basically what I heard you saying is that the SSIR tariff, the new one, went into effect on, what was it, May 13th, did you say?
Correct.
And does it, did you say that it includes the method for calculating the weighted average cost of debt that's going to apply to SSIR amounts?
It specifies that it was the cost of debt, long-term debt approved in the rate case, and that it will be grossed up for taxes. And that language was circulated to the parties as part of conferral before the compliance filing was made, and no party protested that filing, that rate going into effect. And so I think this is where we have the bit of confusion, as Mr. Valentine noted, and I agree, that tariff that was not suspended is not properly before you, but the SSIR debt issue was part of this remand order. And my theory is I don't think the commission quite understood that they were different debt costs, and that we're talking about short-term debt on gas storage in the GCA and long-term debt in the SSIR.
Yeah, well, I'm going to assume that the commission did understand that. So what's going to, tell me again, Mr. Stoffel, I'm not as versed in the SSIR mechanics as I think you are at this point. What's going to happen later this year? So, January 1st, 2024 is the triggering date. Go ahead and tell me what's going to happen between now and January 1st, 2024.
So Atmos Energy will make an advice letter filing later this year. I believe that's on November 1st. And that will calculate the new SSIR rate based on projected investments in new projects in 2024. And that will have a debt return on those projects pursuant to the tariff that's in effect. And that rate will take effect on January 1st. So that's why in the tariff, you kind of have two things happening. We specified the changes to the return on 2024 and 2025 investments pursuant to the decision in the rate case. And otherwise, then that will be implemented through a rate filing that doesn't change those procedures later this year.
So, okay. And now it's coming back to me. Thank you for being patient. So, basically the filing as of November 1st, 2023 is going to specify the amounts that are anticipated to be expended, SSIR expenses that will then be recovered through the SSIR pursuant to rates that will be calculated based on those anticipated expenses, and the application of the weighted average cost of debt to those expenses, which will then yield a rate.
Correct.
I have that right?
And
Okay.
and it's layering, just to make sure we're clear, because the 2022 investments, the SSIR investments stayed in the SSIR.
Right.
2023 investments are in there as well. It will now be layering in those 24 projects on top of that,
Yep.
determining
So-
the new rate. Yeah,
So it's not just the expenses anticipated in 2024 and 2025. It's going to be any remaining expenses from 2022 and 2023 in the SSIR. Right, okay, plus the anticipated expenses going forward. Do I have that right? At
Correct.
least conceptually?
correct.
Okay, so what you're saying is the method of calculating the weighted average cost of debt that are going to be applied to those SSIR amounts is specified in the tariff that went into effect on May 13th. So what we know based on what's in effect, or what we know right now, is how to calculate the weighted average cost of debt, because that's in the tariff that went into effect on May 13th. We know more or less, I mean, the amounts in the SSIR currently. What we don't know are the anticipated expenses for 2024 and 2025, which is going to be included in the November 1st filing.
Correct.
And then that November 1st filing, what procedurally, what is it? Is it an advice letter?
It's an advice letter with a January 1st effective date, and then with supporting information in terms of the calculation of the rate and details regarding the 2024 SSIR projects.
Okay. All right. Mr. Bunker, Mr. Valentine, you have anything further on that, or anything else?
No, Your Honor.
Well, only to clarify, Your Honor, that we do not think there ought to be the tax gross up component for the SSIR. And so I think it is still an issue that's at play.
Okay.
However, that language was provided before the compliance filing was made, was in the compliance filing, and was not protested or suspended, leading to this proceeding.
Well, let me just say that, and I'll direct this primarily to Mr. Stoffel. I mean, if I adopt your proposal, just for the schedule here, it's based on the assumption that, Atmos has the burden of proof. And, like I said, what's been remanded are two issues. And I understand and hear what you're saying about the second issue, the weighted average cost of debt. But if I adopt your proposal, if I adopt your proposal, I would anticipate, seeing in your direct testimony, testimony regarding the second issue, weighted average cost of debt. And, I'm not going to specify what you need to say, your witnesses need to say in that testimony, but, in my view, particularly if I adopt that proposal, it's your burden of proof to establish whatever you want to establish with respect to the second issue, the weighted average cost of debt, which presumably is, what's in the tariff that's currently in effect is correct and should not be altered.
Understood.
So, I tell you what, under either proposal, what are the proposed deadlines for direct testimony, for first round of testimony?
Under
Go
our
ahead.
proposal, it was July 28th. And we're working toward that deadline. Under the UCA proposal, it was August 4th.
Okay. Give me just one moment.
And Your Honor, if it's helpful, the schedule is about a week later for both direct and answer testimony under the UCA proposal, because it's cutting out that rebuttal testimony at the back end. And so it shifts the schedule about a week for direct testimony and for answer testimony to give a little more time for those two rounds of testimony, and essentially the deletion or exclusion of the rebuttal testimony phase.
Understood. Thank you for that clarification, Mr. Bunker. All right, well, here's what I'm going to do. I'm going to go ahead and I'll follow this up with an interim decision, written interim decision memorializing this, but I'm going to go ahead and adopt the procedural schedule proposed by Atmos with one addition. I'm going to add a response date for two pre-hearing motions. The pre-hearing motion deadline in the schedule proposed by Atmos was September 15th, 2023. I'm going to adopt that and the other parts of the schedule proposed by Atmos and supported by staff. But I'm going to add a response deadline to those pre-hearing motions, which is going to be a week later on September 22nd, 2023. Otherwise, as I said, the schedule proposed by Atmos and supported by staff will be adopted. I hear what you're saying, Mr. Bunker, about getting as fulsome of a record on both of these issues as possible. And I'm confident that using Atmos's proposed schedule with a more traditional 3 layers of written testimony and then having a hearing is going to provide that fulsome record that I'm going to need and that the commissioners are ultimately going to need in order to decide this issue. I would ask all of you to do your usual great job on producing that fulsome record. As you're developing your direct answer and rebuttal, just keep your eye on that. And try to give us as much as you think we need, me and then ultimately the commissioners, to decide these two issues. So as I said, I'm going to follow up with a written interim decision that will memorialize this. But that's my decision. So with that, is there anything further that you'd like me to address today? I'll turn to you, Mr. Stoffel, first.
One minor housekeeping matter that we did want to just bring to your honor's attention. Perhaps you're aware that in the last interim decision you issued, the preceding numbers were wrong. So if you were to take that as your template for the next order, you want to make sure you're capturing the correct preceding numbers.
Okay. Give me just a moment. I wasn't aware of that, actually.
I wasn't either until I copied them into an email line and was informed they were incorrect.
Give me just a moment. Oh, I see. Okay, I got it. Thank
Yep.
you very much for pointing that out to me. I appreciate it.
Of course.
Mr. Valentine, do you have anything further?
Nothing further, Your Honor. Thank you.
Thank you. And Mr. Bunker?
One other housekeeping matter, Your Honor, statement of position date. Currently, under both schedules, we had to be decided by you, Your Honor. And do you have any thoughts on that now, or would you wait until the hearing to make that decision, or?
My inclination is to wait until the hearing and see what the record looks like. At that point, so does anybody, I'm assuming nobody has a problem with that, given that it was a TBD for me.
No concerns from Atmos.
No problem, Your Honor. I just was curious if we had that date that would be coming in your order memorializing today.
It will not. I'll just leave it to be determined.
Excellent. Thank you.
Okay, thank you. All right, so let me thank all of you. And time is short, so I look forward to getting the first round of testimony here soon. So with that, I'll say that we are adjourned. Thank you.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.